back here for our panel 7 on climate litigation, and I'm extremely happy to have this great panel together here. It's going to be a great conversation. We changed the order of the presentations. So first we are going to hear from Professor Camille Cameron. She is a professor here, our former dean. She began her career in private practice in a commercial law firm here in Halifax. She specialized in civil litigation. She also, while in practice, she was a frequent presenter of legal education seminars. She taught civil trial practice as a sessional lecturer before joining as faculty here. She also has an LLM from University of Cambridge. She has worked and traveled extensively, so she has taken an academic appointment in Hong Kong. Prior to joining Schulich School of Law as dean, she also had held academic positions at the University of Windsor and University of Melbourne, Australia. She also served as Associate Dean and Director of the Civil Justice Research Group in Melbourne, in Australia. Her research interests are in comparative law and legal institutions in post-conflict societies. That interest led her to Cambodia and also to Vietnam, Laos, Mongolia, China, Thailand, Indonesia. So she has vast experience, international experience as well. And she has served in numerous committees dealing with academic and senior administrative appointments. It's very long, lots of accomplishments.
Forget it, that's enough. There's a shorter version.
Without further ado, what I'm going to do, I'm going to pass the floor to Professor Cameron. In the end, I'm going to introduce Erin and then Kolawole when it's their turn to take the floor.
All right, thanks very much, Patricia. So in the time I have, I'm going to talk a little bit about climate change litigation, and in particular focused on a project I'm working on with some colleagues, and I'll explain that to you in a moment. I don't have slides, I hope that's okay. I focused the title of the presentation on climate change, is it worth it? A very pithy question for a subject which is far from pithy. And the answer is, yes, it is. But there's a couple of other questions that go with that. One is it complex? Yes, climate change litigation is extremely complex, as is the subject itself. Is it fraught with challenges? Absolutely, no question about it. But that said, is it worth it? Yes, it is. And I'll spend a little bit of time talking first of all about the landscape of civil litigation in climate change. I'll talk a little bit about the project and some of our learnings so far from the project. Let's talk just a little bit first about the climate litigation landscape. Updating the stats using a number of sources, United Nations Environment Program, Sabin Center, and the Grantham Institute at LSE, the number now is around 2,571 cases. The number of jurisdictions where these cases are taking place in courts has expanded beyond the 65 number that was reported in around 2023. So just let me give you an idea of how the numbers are growing. Citizens, civil society, and environmental organizations throughout the world are increasingly turning to the courts to find solutions to the perils of climate change. Here are some stats. Just to give you a picture, as of November 22, UNEP reported that there were 2,180 climate change litigation cases underway throughout the world, that this number was 2.5 times higher than it was 5 years earlier, and that the number of jurisdictions involved had grown, get this, from 24 in 2017 to 39 in 2020 to 65 in 2023. And it seems now that the number of jurisdictions in which cases are unfolding is in the vicinity of 68 or 69. Okay, so with that background in mind, I'm working on a project with Professor Patricia Galvâo Ferreira and Riley Wayman, JD19, who's now at Papes Alter and we are basically trying to do an in-depth look at some key landmark cases in climate change. It's part of an Edward Elgar Cases in Context series, and the aim of the series, of which this book is a contribution, is to provide a space to analyze notable cases in thematic areas of law and to examine those cases in depth, to look for cases that grapple with novel approaches, depart from precedent, and raise important questions for further investigation. So we're undertaking a close examination of climate cases. We've got 11 underway from various courts and jurisdictions, including, of course, Global South and Global North cases. What are we looking at? We're looking at what are the claims, who are the parties, of course, what are the jurisdictions, what about the role of interveners, who are they involved? Process issues, what are the challenges, who's paying for it? Right? What are the cost issues and what are the cost barriers and how are they being dealt with? What are the outcomes and what are any local, national, or transnational impacts? So that's basically the approach we're taking. Why are we doing it? There's lots of other things we could be doing with our time, so why are we doing this? Well, it's clear, you just saw the stats, I mentioned them to you, litigation has become an increasingly popular way to address climate change challenges. And as the amount of litigation has increased, so has the academic literature and the academic discussion and the academic analysis. And this project then is an opportunity to look at some of the cases in depth. Just a few big picture points before I talk about some of the things that are developing from our research and our case studies. First of all, the literature is vast on issues around the value of litigation as a regulatory tool, way too vast for me to even dip a toe into it here. Kola is doing an entire PhD thesis on it, so it's a big topic. What's the dominant theme, though, in the literature? Are there regulatory or policy advantages to be gained from bringing a dispute to litigation? That's the simplified, that's the question. Now, apart from climate litigation, this discussion has unfolded over the decades in the context of complex areas like tobacco, opioids, asbestos, and more recently, the impact of social media algorithms on young people, their mental health, and their ability to learn. So these are some of the areas that have sort of given impetus to discussions around the value of litigation as a regulatory or a policy-making tool. And these cases, those areas that I've just mentioned, have also been the subject of very considerable debate. So why? Often it's a result of policy or legislation gaps and deficiencies. That's often why resort to litigation is had. And often the cases are brought as some form of collective litigation, which is really how my interest started, because I have an interest in collective litigation. And why collective litigation? I think to offset the very significant power imbalances that are baked into most civil litigation processes. There's various reasons also to resort to the courts to adjudicate climate disputes. One major reason is dissatisfaction with the failure or complete lack of other regulatory processes or frameworks to deal meaningfully with climate change challenges. Another reason is that the complexity of climate change lends itself to a variety of approaches, a variety of attempted solutions, one of which is being chosen by actors, climate litigation. And a factor that can be both a reason for and a result of climate change litigation is litigation's capacity to build or strengthen social political networks and to educate, okay? Is it worth it? That's my question. So I'm going to just say a few things about the case studies we've looked at to talk about ways that it's worth it and ways that it might not be. All of the cases we're examining have been described as groundbreaking, firsts, landmark, or in some other way, and that's the cases we've picked. Some are decided and some are ongoing. And of course, they're ongoing because one of the problems with litigation is it takes so long to get through the process, okay? So that's an issue. All right. In the time I've got, let me just identify some of the issues that have come up in the litigation, have been dealt with, and I'll leave it to you to assess whether you think they've been addressed. One is justiciability, or the political question, okay? Most of the cases that are in the number of cases that I've told you about are brought against governments. So in this way, our sample is representative because most of our cases are also brought against state, provincial, or federal governments. Typically, these claims, however presented, are met by a motion to strike. One of the arguments raised by governments on such applications is that the claims are not justiciable. This argument can be presented in various ways, but it's always informed by the theme that the separation of powers as between the judiciary on the one hand and on the other hand the legislature and the executive branches would be violated if the courts got involved. So that's a very common argument. We saw it in a Canadian case, Mather. We saw it in a case from Brazil that we're looking at, PSB versus the Climate Fund. That is a case, the Brazil case, for example, the defendant government argued that courts should not interfere in polycentric matters best left to the legislature and the executive branches. The court disagreed in that case, ruling that the Brazilian government's suspension of the Climate Fund was a violation of the government's obligations stated in the legislation to disperse the funds for climate projects. So that's one example. I won't mention a similar example from Mather. Erin might touch on it when she speaks. Another learning, can I say this, from the litigation, and one that I have continued to be impressed with, is the extent to which courts are accepting and endorsing international climate science. And this, in my view, is one of the most striking features of many of the decisions. For example, Held versus Montana. Some of you will be familiar with that case. Some young people brought the case in Montana. A key witness for the plaintiffs was Dr. Stephen Running, professor emeritus at the University of Montana, and as luck would have it from the point of view of the plaintiffs, and a lead author of the Intergovernmental Panel on Climate Change Fourth Assessment Report. The court accepted his evidence without much question at all. And that was a situation in which the state of Montana really didn't have much they could do to counter his evidence. Similarly, in Mather, there were very strong comments from the Mather court endorsing international climate science as determined by the IPCC. Some of the words the court used: reliable, comprehensive, and authoritative synthesis of existing scientific knowledge about climate change and its impacts. So these are two examples of cases in which the science has been accepted. Okay, another learning, and this is one I was quite interested to hear yesterday's talk about Indigenous law. There are several cases which deal with Indigenous law. I'll mention just one. Smith versus Fonterra. A legal question raised in this case concerns the capacity of tort law in common law jurisdictions to respond to the threats and harms of rising GHG emissions. The case is brought by a Maori elder against 7 corporate defendants who are among the biggest emitters and fossil fuel providers in New Zealand. The case has yet to be heard on the merits, another example of going through various stages as it's resisted. But it has received a lot of attention. And especially the attention is for the Supreme Court's affirmation of the relevance of Takonga, Maori law, in the context of the case. And so I think that is an example of the extent to which there's an increasing attempt on the part of Indigenous people to bring Indigenous law, not just custom, but Indigenous law to the court in the context of climate change. One of our authors, I'll just quickly state this, his view about the case is less certain but perhaps more intriguing is the potential for Takonga, Maori law, to more radically reshape tort doctrine, including, as addressed in submissions in the court, providing impetus for judicial adoption of an alternative lens with reduced focus on individualized relational proximity and greater weight given to ecocentric conceptions of harm and proximity. There's a Canadian case as well, which I won't deal with. Now, time is running out, so I'll just briefly mention a few other things. One of the themes that occurs a lot in the case is the de minimis argument. It was a strong argument in the Held case, which was basically the comment of the state was Montanans, people from Montana, did not cause climate change. And that de minimis argument is raised very often. Yes, okay, we're part of a problem, there are emissions issues, but it's a global problem. It's a drop in the bucket. That argument is being rejected by courts in Canada and elsewhere, and I think that's quite an achievement, actually. I think I'm running out of time. There are limits to litigation. One of our case studies from China talks about the fact that really without significant systemic change, there's only so far that litigation can take it. However, the Chinese NGO, Friends of Nature, that is bringing cases in China is bringing them not necessarily to win the individual case, right, but to achieve other ends. And that is one of the purposes that's identified by people who are pursuing it. An Australia case, a greenwashing case, again, some useful results. It was the first time that the litigator took such a case in Australia, but as it's pointed out by people, regulators have capacity constraints and they do not have a clear mandate regarding their role in addressing climate concerns. So her comment, that author, is really you can't use traditional corporate concepts to deal with these cases. We have to change the lens through which we're looking at things. I wouldn't talk about federalism except to say that it's a problem. And it comes up a lot in various cases we studied, and all the fragmentation and the politics that goes along with it. So, and I also won't mention redressability and remedy, which is a tough issue that we're struggling with in terms of how we address that, because it's one thing to get a really good decision from a court, a really good comment. It's another thing for the court to be able to declare an effective remedy. So I'll end there.
Thank you for this great overview of climate litigation globally, and also for highlighting some of those key issues. And I think it shows how rich this whole debate about climate litigation has become. Our second speaker is Erin Dobbelsteyn. She is our colleague here. She's been teaching torts and also the health law seminar here at Schulich. She's a doctoral candidate at the University of Ottawa and a Schulich Fellow here at Dalhousie University, Schulich School of Law. She has been engaged in research and community activities related to environmental rights, climate justice, and public and planetary health. Erin represented Friends of the Earth Canada before the Ontario Superior Court of Justice and Court of Appeal as an intervener in the human rights-based Climate Charter Challenge, Matur versus v. Ontario.
Okay, great. So, hi everyone. It's so nice to be here with you all. I'm really delighted to have been invited to be a part of this panel, part of this conference to celebrate MELP and MELAW, and to be a part of the MELP and MELAW community. I graduated from the Schulich School of Law many years ago, and it's been so nice to come back home and seen all the ways that things have changed and grown in the years, and to be a part of it. So this morning I'm going to provide you with a very brief overview of human rights-based climate change litigation in Canada. So we're going from the broader global context to the Canadian context now, and I'm going to have a specific focus on charter-based human rights litigation. So looking at the successes that we've seen so far, the outstanding challenges, and then I'll also give some reflections on climate litigation beyond the charter. Okay, so these are statements made by the Supreme Court of Canada in the 2021 references greenhouse gas emissions Greenhouse Gas Pollution Pricing Act decision. So here we see the Supreme Court of Canada identifying climate change as an existential threat to the country, to the world, and to the future of humanity, and noting that the only way to address this threat is to reduce greenhouse gas emissions. So over the last 7 years, on the heels of the success of rights-based climate change litigation in other countries, we have seen a rise in human rights-based climate change litigation or climate charter challenges in Canada. So these are one tool or one particular litigation strategy that is being used to compel Canadian governments to take action to address the existential threat of climate change. So as many of you know, the Canadian Charter of Rights and Freedoms does not contain the right to a healthy environment, nor any explicit substantive environmental rights for that matter. But there are 5 Canadian human rights-based climate change cases launched to date, which are relying on Section 7 and Section 15 to challenge the inadequacy of government action or inaction on climate change. Led largely by children, youth, and Indigenous groups and communities who disproportionately bear the burden of climate harms, these cases are part of the fight for substantive elements of the right to a healthy environment, like clean air and safe water, and for climate justice. The first Canadian climate change charter claim was Environnement Jeunesse in Canada, and that was a class action that was brought in Quebec in 2018 on behalf of all Canadians 35 and under. The courts refused eventually to certify the class action, and the Supreme Court of Canada dismissed the leave to appeal in 2022. In La Rose in Canada, 15 youth from across the country sued the federal government, claiming that national action and inaction on climate change has led to a level of GHG emissions that is incompatible with a stable climate system, and that this violates their rights and the rights of all children and youth in Canada, past, present, and future. So the federal government brought a successful motion to strike the claim, and the youth appealed that to the Federal Court of Appeal. At that level, the claims based on Section 15 and on the public trust doctrine were dismissed, but the Court of Appeal allowed the Section 7 claim to proceed with amendments to the applicant's proceedings. So we now have an 8-week trial that has been scheduled before the federal court that is set to begin in October of next year, October of 2026. And the appeal in La Rose was heard at the same time as the appeal in another successful motion to strike in another case, Misdi Yik in Canada. So in that case, the hereditary chiefs of 2 Wet'suwet'en house groups alleged that by repeatedly failing to meet its international commitments, Canada was breaching their charter rights as well as those of future generations of Wet'suwet'en House members due to threats to their identity, to culture, to food security, and their relationship with the land and the life on it. So this case, like La Rose, has now been given the green light to proceed to trial on the Section 7 claim, but we don't have a date set yet for the trial in that case. One of the most recent charter climate claims is Dykstra and Saskatchewan. That is a case that was launched in March of 2023 by 7 residents of Saskatchewan aged 15 to 80, so not only youth here in this case. And this was along with the community organization Climate Justice Saskatoon. And the claimants in this case allege that the expansion of gas-fired electricity generation in the province violates their charter rights. So they brought it against the government of Saskatchewan as well as a number of crown corporations. And unsurprisingly, we see the government here again bringing a motion to strike to have the claim thrown out before the full evidence is heard. And we're currently awaiting a decision from a judge on that motion that was held in October of 2024. So you may have recently heard something about these kinds of climate cases in the news. On May 1st, we had the Supreme Court of Canada dismissing Ontario's application for leave to appeal in Mather in Ontario. So before I discuss the Supreme Court of Canada's dismissal in this case and why it's being celebrated as a win for the youth applicants, you need to know a little bit more about Mather and his journey through the courts. So I'll add on to what Professor Cameron has already mentioned. So Mather is the climate charter case in Canada that has made it the furthest so far in the Canadian courts. It was the first to clear all of the initial procedural hurdles and to have a full hearing on the merits. The applicants in this case are a group of 7 youth. They are all engaged in climate activities they are known as and recognized as climate leaders, and 3 of these youth are from First Nations in Ontario. So the background context of this case is that when Doug Ford was elected in 2018, his government passed legislation to significantly roll back what were seen then as relatively progressive climate targets, and that those targets were replaced with a single, significantly weakened target. And so the Mather youth challenged that legislation and the new target as violating their Section 7 and Section 15 rights, as well as the rights of all youth and future generations of Ontarians. And what they're asking the court for is an order requiring Ontario to set a science-based GHG target that is aligned with what the international consensus is on the emissions necessary to minimize the worst impacts of climate change. So here is a visual history of where this case has been so far, and I'm just going to focus on the final 3 decisions here, which collectively continue to make Mather, and here I'm going to say it, groundbreaking and very exciting from a doctrinal, both constitutional and climate litigation perspective. So after a full hearing before the Superior Court of Justice, the application judge dismissed the claims of the youth applicants. She found that the target itself did fall severely short of what the scientific consensus is on the reductions necessary to mitigate the most catastrophic impacts of climate change, and that this gap between Ontario's target and the global standard was large, unexplained, and without scientific basis. And she found that this was leading to an increase in the risk of harm and death to Ontarians. So that was a very significant finding. She did not, however, ultimately find any violations of the charter. She didn't find the target ultimately to be unconstitutional. And largely this turned on her finding that this was a case seeking positive rights, and that the applicants here hadn't established a violation of the principles of fundamental justice, or that Section 15 gave rise to positive obligations. So despite that disappointing outcome, there were some really important precedents set here for climate charter litigation, including justiciability, finding that these claims that the court did have authority and competence to deal with these claims. And as Professor Cameron mentioned, there were some great comments about there was adoption of the international scientific evidence as authoritative and credible. So IPCC reports were accepted, and almost all of the applicants' expert evidence about the risk and harms that climate change poses to Ontarians, youth, and future generations, including its disproportionate impacts on youth and Indigenous peoples, was accepted. So the youth then successfully appealed this decision, this dismissal of their claims to the Ontario Court of Appeal. So in October of last year, the Court of Appeal confirmed that this kind of government climate policy can be reviewed for compliance with the Charter. And it went on to hold that the application judge had erred in framing this as a positive rights case. But rather than deciding the charter claims themselves, they decided to send the matter back, so tossing this political hot potato around, back to the lower court for a new hearing with the guidance that it was providing. One of the positive things that came out of the Court of Appeal was some comments on remedy that we haven't yet seen. So the Court of Appeal disagreed with an argument made by Ontario that the applicants are asking the courts here to take control over environmental policy. The Court of Appeal admitted, yes, there could be some separation of powers concerns here at the remedies issue, at the remedies stage, but if the application is successful in this case, ultimately a proper remedy can be determined by a court with reference to those international standards based on accepted scientific consensus. So Ontario's application for leave to appeal to the Supreme Court of Canada, as you saw in the news, was dismissed. Where does that leave us? Where do things stand? Well, the SCC's refusal to hear Ontario's appeal preserves the Court of Appeal's decision that government's GHG targets have to comply with the Charter. They are reviewable for Charter compliance. It also preserves the finding that Mather is not a positive rights case, and that Ontario's inadequate and unscientific target is exacerbating the risk to the lives and health of all people in Ontario. From a personal standpoint, I was really hoping that the Supreme Court of Canada was going to take up this appeal. I don't think there's any guarantees that they would have done what EcoJustice and Stockwoods, the lawyers for the applicants, were asking in the cross appeal, which was to complete the charter analysis themselves if they were going to hear Ontario's appeal. But I do think it would have been nice to have some guidance from the Supreme Court of Canada sooner rather than later on these challenging constitutional issues, because it would have implications not only for Mather, but for the other ongoing climate charter cases in Canada, as well as other cases that do not have to deal specifically with the charter, but are dealing with socioeconomic rights in Canada. So personal disappointments aside, I do agree that there are aspects of this case, of the dismissal of the appeal, that we can celebrate as a win. And hopefully we will not have to wait years for a hearing date for the new hearing in Mather. So just a quick comment on some of the outstanding issues and hurdles on the path to a successful Canadian climate charter case. Beyond the lengthy timelines and the inherent delay in litigation, Mather and the other charter challenges face many hurdles. The cases involve significant evidentiary burdens and raise complex and unsettled constitutional issues like standing for future generations, the application of international law, including international environmental law, to the interpretation of charter rights, the justiciability of issues that are perceived as requiring judges to weigh in to highly political realms of policy and lawmaking, the appropriateness of these novel remedies that are being sought in these cases, the recognition of unwritten constitutional principles. So in Mather, there have been arguments that the court should recognize an unwritten constitutional principle of societal preservation and of ecological sustainability, and that those should influence the court's charter analysis. And there are many more. So in my research, I've been proposing ways to overcome some of these hurdles, and I have a paper that's coming out hopefully in the next couple of months specifically on the positive rights issue and the principles of fundamental justice under Section 7. And I think to sum it up, I'm really arguing that courts do have the authority, they have the precedent, they have the tools to adjudicate these charter claims and to find the government's inadequate responses to the existential threat of climate change unconstitutional. What they really just need here now is some courage. So finally, beyond the charter in Canadian climate litigation. So we're now 8 years into the wave of climate litigation under the charter in Canada. But it's still going to be quite some time before we get a definitive conclusion on the charter's role in addressing the existential threat of climate change. So climate litigation relying on the charter, I think, needs to be seen as only one tool in our toolkit, in our litigation toolkit. We also need to be thinking beyond the charter to other forms of climate litigation that is already underway and that could be underway in the future, that aims to hold not only Canadian governments but also corporate actors accountable for climate and human rights obligations. And I think this is particularly important when we're at this very precarious time where we're seeing rollbacks in environmental protection legislation, some doubling down on fossil fuel development and infrastructure, and really significant attacks on individuals and communities who are exercising their rights to raise awareness of environmental and human rights concerns. So I've offered here a few of the many, many possibilities to ponder together, and I would also refer you to an excellent paper that was written by Professor Sarah Seck along with Lisa Benjamin in 2021 that maps out human rights-based climate change litigation in Canada, including options for climate corporate accountability, procedural environmental human rights-based litigation as well. And as have already run out of time, I won't go into this into detail, but maybe we could chat about it a little further in the discussion. I think some of the possibility for polluter pays cases of holding fossil fuel companies accountable for climate harms is really, really interesting. And just earlier this month, we saw the, I think, 11th community sign on to a campaign that's being run by West Coast Environmental Law called Sue Big Oil, where municipalities in British Columbia are agreeing to contribute $1 per resident towards a lawsuit against fossil fuel companies. So we don't know when yet they might launch that, but it's exciting to see that these kinds of cases that have been launched in other countries are now being considered in Canada. And I think just to wrap it up, I just want to note that there's significant potential for rights-based climate litigation in Canada to contribute to addressing the climate change crisis and to pushing governments and businesses to take climate action. So I know that the number of cases is only continue to increase in the years ahead, and it's going to take many different forms, including beyond the Charter. So thank you very much.
Thank you very much, Erin, for this comprehensive picture of climate litigation in Canada, especially human rights-based climate litigation. Some of your comments at the end talking about rollbacks and some headwinds faced by some climate and environmental activists is a good segue for our last but not least panelist, Kolawole Abiri. He is a PhD candidate here at Schulich School of Law. He's also teaching part-time Law and Ethics for Chemical Engineers, Introduction to Environmental Law and Law in its national and international context here at Dalhousie Schulich School of Law. His research focuses on climate change law and policies, climate litigation, the intersections between climate change and energy, climate and environmental justice, impact assessment, international environmental law, and how to use mechanisms of impact assessment to achieve sustainable development goals. He holds a Master's of Law from the Arctic University of Norway, a Master's of Legal Science from Uppsala University in Sweden, and one in international comparative law from the University of Eastern Finland. He has a Bachelor of Law from University of Ilorin in Nigeria, and also over 22 years of litigation experience in Nigeria. His doctoral research does a deep dive into the role, very deep dive, into the role of courts in climate governance. And we are in for a treat, anyone that is reading his doctoral research chapters, because he covers a lot of ground in terms of theory. So it's a treat for all of us to hear from him. By the title of his presentation, I'm hoping that it's not going to be too pessimistic. And thinking about Star Wars, it's going not to tell us that the dark side of the force on climate litigation is rising now.
It's a privilege to be here this afternoon, and I'm also privileged to have all my supervisors, including my committee member, present. With the benefit of having listened to my co-supervisor, and other speaker, it's like I don't really have much to say. But my topic is actually about situating litigation within the broader space of governance. And when I chose the topic, I was speaking from different parts of my thesis. And eventually, I felt that I need to reduce it. And I'm also fortunate that some of the areas that I will have covered have been addressed by the previous speakers. So the overview of what I'll be discussing this afternoon, since I'm situating litigation within the broader space of governance mechanism, it's important that we know what this litigation, this tool, seeks to address. And that brings us to the issue of the commons. And then what's the problem with it? The approach and arguments, the characteristics, and the limitation. So we have the common pool resources, and the benefit of our discussion yesterday of what common heritage, and I felt that it's very important that we understand why litigation or other tools of governance are facing challenges. First, we have the here. Yes, we already have the UNFCCC, the Paris Agreement that seeks to govern the space. We have the oceans. We have the UNCLOS Plus with other regulations and other approaches to ensure that we have a clean ocean. But the problem is with the land, where it's essentially governed by private rights. Kevin addressed that, especially in the context of Nova Scotia, that on more than 70% of the land rights is under private ownership. So we have the land, the private rights, and public regulations. So what's the problem? In 1968, I think, I know, or I presume that most of us are familiar with this article, the tragedy of the commons. And he identified these three problems: the problem of overpopulation, overexploitation, and problem of pollution. And these are the problems that were identified almost 60 years ago. And the first one they identified has remained unregulated. And if you look at, I put it in context, the world population as of 1968, when he wrote the article of overpopulation, was 3.3 billion, 3.5 billion. And the density per kilometer was 24. In 2025, it's more than 8 billion. And by 2050, it's projected to be above 9 billion, going to 10 billion. So overpopulation had not been addressed. And then overpopulation also leads to overexploitation. Even if population had remained the same, the overexploitation had not been addressed fully. And then we have the last one, which is the problem of pollution. So according to heading, taking something out of the commons, but of putting something in, for instance, sewage, chemicals, radioactive, and heat waves into water noxious and dangerous into the air. These are precipitate for disaster. So the complexity of the commons that we have, I put them in this way to show the geographic scale of it is global and transboundary. The number of resources that we have millions of people that are involved trying to exploit these resources. And then the capacity of the resources are exhaustible, and depletable. And there is this other consideration that they are non-excludable. You cannot exclude anyone from enjoying the air, the water, and the land. And then the distribution, the salience, and all other complexity of the commons. So leads us to injustices of overexploitation and pollution. Overexploitation of the commons present three distinct dimensions of relational justice or injustices. The first one, justice among states, which we refer to as international justice, or justice across generation, intergenerational justice, and justice within states and across generations, which is intragenerational justice. So this, we have to put governance mechanism within this context. And then, why is the concept of justice very significant? We need to ask that question. It's very significant because the notion of climate justice attempts to furnish a normative justice ideal for the global climate change framework. Thank you. And second, the existence of legal framework of climate policy making is not required to advance climate justice. If you look at the framework of climate change architecture, there is no deliberate intention to advance justice cause. And then the third one is that the notion of justice is also associated with a system of accountability, retribution, and remedies for injustice. So the concept of justice is very significant. And governing the commons. So these are the tools we have. We've always had this tool of state coercion through regulation plus strict enforcement regime. And then we have the tool of the market, privatization and market-based mechanism, whereby an external authority establishes rules for fencing, for common, and allocating property rights. So we also have the collective action as one of the means of governing the common. And so many scholars advanced different theories or various theories of collective action. And the dominant one being polycentric governance and governance, global cooperation, or multi-level governance. And then we also have the voluntary action, either through self-regulation, voluntary commitment, global cooperation. Now, scholars, in advancing different approaches to addressing the problems of the commons, interestingly or surprisingly overlooked this aspect of litigation. And I'm going to argue that it's very important that we need to look at what litigation can do. Another reason why we need to address this issue of justice and why the regime of regulations, of market, of collective actions, or voluntary action may not really work is because we've been having declining government, which some scholars have described as hollow house system. Modern society has become too complex, sprawling, and unpredictable to be governed by the whole governance system. And again, we say that the traditional governance too have become very weak, inadequate, and obsolete. And why? And Metty gave 3 reasons, which are characterized as corporate oligarchy, increasing decentralization, and globalization. They have made many states to be very weak. And then we have the failure of the Western model. Overexploitation has been linked to political liberalization, free market economy, because it promotes profit maximization or lack of regulation. Anytime there's regulation, there's always a challenge of that regulation. Or we have weak regulation, or regulatory capture, or even deregulation. And then we also have free riding. So Western model has been really attacked that it may not be the real model to address this challenge. And Mark Besson made this argument. And I want to show you this, why his argument makes some sense. Alternative model. He chose China. We see the problem of overpopulation in China have been addressed because of what he called authoritarianism for positive good. And many of the scholars that have addressed this issue of how to govern the commons have always criticized the Eastern approach. They've always presented the Western approach as the best model, not looking at any value that the Eastern approach can bring. For instance, comparatively, if we look at the rise in global emission, though China has more than 1.3 billion population, and the production activities in China, economic productivity, had increased exponentially, yet per capita emission is very low compared to most of the Western countries. I want to quickly wrap up, although I have so many things I want to say. Adjudication, I describe adjudication as a legal process. It's a political process. It's a social process. It's an economic process. And I argue that judicialization actually represents what litigation should do. And again, I want to address this point because I feel it's very important, the role of litigation. Generally, litigation is seen as a model of dispute resolution, but that is the whole idea of litigation. Litigation is more or less of legal interpretation and legal development, and it allows for institutional recognition of dispute. It also allows for exchange of proofs and reason argument, as well as transparent deliberation and participation that you may not see either in Congress or in the Parliament. And lastly, I argue that litigation can actually be a forum for juris persuasion, that it's not really about the outcome of cases, whether you win or you lose, but how reasons arguments are presented, are demonstrated, articulated, and begins the topics for discussion. And notwithstanding that, I also note that there are limitations to it, and one of it is being discussed, polycentricity of climate dispute, as well as what Dworkin referred to as hard cases. Thank you.
I was not expecting the authoritarianism to be China imposing environmental standards. Thank you so much for this thought-provoking presentation. We will take 10 minutes, and Sarah, are you already raising your hand? Okay, so I'm going to open up for questions. I have one question here, one question there. Okay, 4 questions already lined up, so perhaps we can get 2 questions and then a round, 2 questions and then a round. Sarah?
So it's a problem. It's one of the barriers, and one of the things you see, one of the interesting things about looking at climate litigation over time is that you see the imaginative things that litigants can do to deal with barriers. Okay, one of them, for example, we saw in Matter was you choose the kind of process you use to begin your claim, and that one is cheaper than the other. Okay, that's one. In terms of costs, you pick a jurisdiction, if it's a class action, where there are no adverse costs in class action. A Swiss case we're looking at, the Klima Sinderinen, they brought it in a way that they created an association for the sole purpose of bringing litigation, and the rules, the Swiss rules regarding the association didn't do away with completely, but limited, right, the extent to which there was cost liability. Another thing that happens, although this is less and less common, I think, in some of the, a case, for example, against the carbonated, because there's so much money involved. But of course, in some cases, lawyers are willing to work on a contingency fee basis. That makes some difference. You also have, for instance, let's take Mather again, eco-justice. There's other cases where charities are the plaintiffs, right? Or you have lawyers acting pro bono. Take the Anjou case, Erin mentioned it. Anjou did not make it all the way, sadly. I thought it might to the Supreme Court of Canada, but as far as the Quebec Court of Appeal. But I spoke a few years ago with the lawyer who was on that case. They were doing a pro bono, a very well-established firm in Quebec. But his comment was that we take other cases where we can make lots, I'm paraphrasing, where we can do well financially to sustain or to support being able to take these other cases. So there's a lot of ways around it. But that said, no question, costs are a deterrent. I don't know if that answers your question, Sarah.
The de minimis? Do you want to address the de minimis quickly?
Okay, I'm going to say just a little bit about de minimis, and then see what, or the drop of the ocean, and then see what Erin says. Basically, and I'm thinking now of two Canadian cases, Mather and LaRose, and maybe Herald as well, but the courts said, and it might not be the deep reason you're looking for, basically, if we do that, then there's never going to be any solutions. I'm paraphrasing, but that's, and in fact, that comment from LaRose was particularly stark and trenchant, I think. But their point was, that can't be right, because if it is, then we all throw up our hands and nothing can be done. So that's basically it. That's how I summarize it. Erin? Okay.
Yeah, I would say that the courts have acknowledged that this is a collective action problem and that every single GHG emission makes a difference. And so, every molecule of CO2, although it may not be much in comparison to some other countries, they say it makes a difference. And so you have a responsibility to reduce your GHG emissions regardless. Yeah. I think the other point is that when you look at it on a per capita basis, the gaps aren't as significant, and the courts are acknowledging that as well. So there's still some debate going on about how a constitutional standard is going to be set of what a particular province or national government in Canada has to do. In Mather, they tried to argue that that Ontario needed to basically reduce its fair share according to the global carbon budget, and the court rejected they said we can't address the issue of fair share because that involves justice and policy and ethical concerns, but we don't have the capacity. So they said we're going to base it solely on your proportion of the global carbon budget based on a per capita basis. So not getting into historical contributions to the climate crisis through the historical GHG emissions or anything like that. So there's still some debate going on around this issue, but I would say they have very much recognized that everyone plays a role in contributing to the crisis, and everyone has to play their role in the solutions.
And I'll just add one more thing. Remember that a lot of these cases are ongoing because it takes so long, right, to get to a full merits hearing. So we'll see what they say when we get to full merits hearings in some of these cases.
Yes, the question on what exploitation of resources by few. Yes, I was starting with that. Yes, firstly, it's very important that we understand that over-exploitation is a part of the problem, and of guided exploitation of resources, because most of the environmental problems or climate problems are based on reliance or the utilization of resources, the amount of resources that are used compared to the amount of resources that we have, and addressing the question of generational justice, whether we at this level can consume these resources and what will be left for the next generation, or compared to the people in other parts. But the problem of overpopulation is also very important, because the more population we have, the more resources that we will need. And if the population is not controlled compared to the resources that we have, then it's going to also lead to the problem of over-exploitation of the resources. Now,
Kolawole, I'm just going to say, many people would say there's an easy solution to that, which is protect women's rights. And that's, so just to say that's the, like, so whenever I hear that, I get frustrated. Which I'm just sharing that with you because I know lots of people do. But, and I think again, it's this, yes, but what about, I want to know about the affluent. Does climate litigation have anything to offer suing the small numbers who exploit at extraordinarily higher levels than most other people in the world?
yeah, I think that has been a challenge of the problem of litigation. Why? Because the affluent, they have the resources. In most cases, they capture the system. So it's very difficult. Secondly, they also have resources to drag out litigation even if you sue them.
Yes.
And even the cost of litigation is insignificant to what they actually enjoy. And the people that are the most vulnerable to climate crisis, they are less resourceful. So, like what I counseled in the previous topic of the repeat players, because they have these resources, they can do so many things. But I think litigation can play a role because studies have shown that the highest contributors or contribution to emission are oil majors. So if we focus on the oil majors, because they contribute more than 60% of the global emission, so we can attack them. And these things are also related to luxury goods like oil and gas industry, like auto industry. So if those people are targeted and the issue of polluter pay and attribution science is raised in litigation, I think we can have a way of addressing that issue of the affluent escaping responsibility or accountability.
Great, thank you. I just want to make sure that we have time for more questions. I think we have Kevin and Constance. Kevin, go ahead.
All right, I'll try to keep it short because I have many thoughts. This was a very interesting panel together for you. I did my master's thesis on this exact question that you were wondering, of should we be litigating this? And that was in 2019. And just a couple reflections on what has changed now. So we're 2025. Easy things to see was the time, right? Like it's striking the headlines for about past 1.5. And like you said, Erin, that they sent it back to the Ontario Court of Justice, right? So where are we going to be at the time when we're dealing with those targets, right? So, but two things that I didn't anticipate at the time. 2019 was very much about climate action, right? We had all those nice rallies before the pandemic. The election was about that. 2021 election was also about it. And here we had our elections now where it was very much about removing actually climate laws. And there was this striking poll about priorities in the election where 68% of candidates have really supported climate action, which is good. But then 75% of candidates said that they support distill that into a question, how can the litigation strike the balance at this point to try to maintain the institutional legitimacy of the court and actually have governments listen and not just use the notwithstanding clause, not just ignore this while still having effective remedies come out of this? And that's the question.
So,
Wait, let's get just a Constance question. Sorry, Camille, and then.
It's much more simple, and it's complimentary, and it was Erin's little like tease of, do I do something in polluter pays approaches? And so I was going to invite you to expand upon that, so I think that should marries quite nicely.
Okay. Yes, please. Sorry about that.
I can't answer your question. I mean, what, we talk about litigation as regulation for polycentric cases, hard cases, wicked cases, some even call them super wicked cases, and so that's what we're talking about. And one of the reasons they're hard or super wicked or wicked is because they exist in a complicated, shifting political framework. That's a reality. You don't know, picking up on what you said, you don't know what the shifts are going to be, and you couldn't have predicted what we're seeing now. But we can't predict what the shifts might be 10 years from now either. So I think to the extent we accept, if we do that litigation has a useful purpose, then we keep trying to use it constructively, and, deal with the slings and arrows of outrageous politics and everything connected with it. That's the best I can do there.
Yeah, I don't think I can do any better than that. I would just add, I think one of the other factors that has perhaps changed, I don't know, significantly would be the adjective I used to describe it, but definitely the role of media, social media, misinformation and disinformation about climate change and environmental issues and politics in general. I think that that's having a huge effect as well. That's really concerning. So I think, just to bring it back to Constance's question, I think it's incredibly important to broaden the strategy as wide as possible, because you're right, Kevin, I think that it's possible that even if we get to the end of one of these cases with a successful finding of a charter violation, it may just be a remedy of declaratory relief that says this target is in violation of Section 7, and we give it back to you, the government, to decide how to comply, to ensure that it's in compliance without anything beyond just, it needs to be, it needs to meet the international standards of, this percentage by this time period. And you're right that it could be that this incentivizes governments to say, especially in the Mather case, because I think that the negative side of framing it as a negative rights case and not as seeking positive obligations to take climate action under the Charter is that it is saying specifically when you pass a climate target, when you put that into law, that has to comply with the Charter. And may that lead to governments just saying, well, then we won't put it into law. It's going to continue to just be a plan or a policy that has no grounding in a legislative instrument so that we don't have to deal with this. It's very possible. So I think it's important to reflect on the other strategies. I do think there's an educative component. I think that there's a movement building component to these cases that we shouldn't lose sight of, and the influence that has on shifting opinions and knowledge around these issues. But I think with the corporate accountability climate litigation, there's also the potential for educating the public more about who is also particularly responsible for these harms, right? And I think that hitting these companies potentially in places where it hurts financially, that might have more of a shifting influence in leading to some positive change in the way that these corporations are going about their human rights obligations and climate obligations. So, yeah, I'll leave it at that. We're way over time, and everybody's probably very hungry.
I know that there are many other questions, But mindful of time, I think that those conversations can move,
Yeah.
yeah, for conversations over lunch.
Continue the discussion over lunch.
Please join me thanking the panelists.